Welcome to the Tenant Law Podcast, where we talk about new, interesting, and/or important legal cases affecting New York City tenants. This podcast will be about 10 minutes long. First, we give you some background so you have the context to understand the case we are discussing. Then we talk about the case itself. And finally, we explain why the case is important and give you our tenant takeaway. I am Michelle Itkowitz, and today's case is Royal Associates versus Gomez, a fairly recent civil court case in Queens County that explores the very important difference between a roommate and a subtenant, and we explain why that difference is so important. First, let's set the stage with some context. What is the difference between a roommate and a subtenant? A roommate lives with you in the apartment. A roommate is a person other than a tenant or a member of a tenant's immediate family occupying an apartment with the consent of the tenant. A roommate is not renting a room from the tenant. That's something totally different. Renting rooms, usually illegal and a topic for another day. But rather, a roommate is sharing the entire apartment with the tenant. Even though the tenant and the roommate might sleep in different bedrooms, they technically each have access to the whole apartment. A subtenancy is totally different. A sublease is a transfer by a tenant of the tenant's legal interest in the apartment. We have talked about this next concept on the pod before, and it's such an important concept that tenants must comprehend in order to understand where most of their rights come from. And it's a little complicated, and it's been suggested to me that maybe it's too complicated for this podcast, but it's my podcast, and I can explain if I want to. And here we go. We're doing this again. It's so important, everybody. A tenancy is not a regular contract. A tenancy is a contract and a conveyance. A conveyance means an exclusive grant of an interest in real property. So when you enter into a lease, your landlord is granting you an interest in the building. Almost like the landlord selling you the building, but not exactly, because the interest that the landlord is giving you is limited. So a lease has a built-in ending date. It terminates on a certain date. And a lease is only for a certain apartment. It's not for the whole building. And a lease is usually conditional. If you don't pay the rent or if you break other rules, a court can evict you. But nevertheless, it's still a grant of an exclusive interest in real property. And that means that the apartment is only yours. And you can keep the whole world out if you want. You can even keep the landlord out. The landlord has certain rights to come in to fix things if they give you the proper notice pursuant to the statute, and in an emergency they can come in and fix things. But in general, the landlord cannot re-enter that apartment unless you give the apartment back to the landlord or a court grants a judgment of possession and a warrant of eviction. So when a tenant gives someone a sublease for an apartment, the tenant is doing the exact same thing with respect to the subtenant that the landlord was doing with respect to the tenant, granting the subtenant an exclusive interest in the apartment. So the tenant cannot go back into the apartment after they do a sublease unless the subtenant gives the apartment back or a court gives the tenant a judgment of possession and issues a warrant of eviction. So a subtenancy is a big deal. Now note, you cannot lock a roommate out either without a court. There's no self-help in eviction in New York, no way. But at least with a roommate situation, you can still be present in the apartment. In the sublet situation, you can't go back in. So in general, the presence of an unrelated individual alone in an apartment, unrelated that is to the tenant, coupled with the absence of the tenant of record in the apartment, generally leads to the conclusion that a sublet has occurred. And that sets the stage for today's case. But before we go on to today's case, I just want to emphasize that the distinction between a roommate and a subtenant has so many implications even beyond this case. And it's not just for rent-stabilized tenants. What I'm about to say in this section is for free market tenants as well. So how you legally form a roommate relationship is very different from how you legally create a subtenancy. And how you terminate a roommate is different from how you terminate a subtenant. And how many people can be your roommates differ from how many subtenants you can have, and the length of time you can have a roommate differs from the length of time you can sublet, especially in the rent stabilization context. We don't have time to cover all these differences in a 10-minute pod. Write to me and let me know if you would like to hear more about roommates and subtenants on another day. But for now, we just need to be able to distinguish between a roommate and a subtenant for purposes of understanding today's case. Now let's get into today's case. Now let's get into today's case. In today's case, our tenants are rent stabilized. I'm making up fake names for them, even though the tenants' names are in the public record. The case is in the public record, but I want to attract less attention to them online. Also, there are 2 tenants and 2 occupants, so there are names all over the place, and it gets confusing. So I'm just going to use one name for the tenant and one name for the occupant, and I'm using a random name generator set to offer mythical fairy names. So our tenant today is Gentle Spice. So landlord issued a 10-day termination notice purporting to terminate the tenancy of Gentle Spice for illegal sublet. Why? Because landlord noticed that Gentle Spice was not living in the apartment. Instead, Beatles Song was living in the apartment. Occupant Beatlesong showed up in court to defend against the eviction case. Beatlesong used the defense that he was not a subtenant of Gentle Spice, but rather he was a relative of Gentle Spice. And Beatlesong said when he first moved into the apartment, he lived for years together with Gentle Spice. Eventually, Gentle Spice moved out, leaving Beatlesong alone in the apartment, but occupant Beatlesong never paid any rent to tenant Gentle Spice. In other words, this was a family using the apartment in a flexible manner. Neither I nor the judge are saying that what this family is doing is not problematic. This may be non-primary residence of a rent-stabilized apartment, but whatever it is or is not, whatever's wrong with the situation, it's not illegal sublet, which is what they were sued for. Why is it not illegal sublet? Because remember, a crucial element of a subtenancy is the handing over of exclusive possession to the occupants, and that simply never happened here. The landlord could not rebut what the tenants were saying, so the landlord lost the case. Now, this leads to some very interesting tenant takeaways. I have 3 of them today for you, but first, housekeeping. This is not legal advice. I'm not your lawyer, but because I am a lawyer, this might be considered legal advertising. If it's legal advertising, it is terrible because I'm asking you not to contact me. This pod is not a commercial for me or my law firm. This is simply the podcast that I always wanted to make. Email us with your questions to answer on the pod. I notice more of you are doing that. I'm very excited about answering them. If you like our work, please give us the 5 stars and put this podcast on your socials. It's time for the tenant takeaway. Tenant takeaway time. 3 tenant takeaways today. Number 1, the landlord probably brought the wrong case against the tenants here. The landlord probably needed to bring a non-primary residence case because rent-stabilized tenants are supposed to live in their apartments as their primary residence. So why did this landlord not bring the correct case? Well, maybe they just didn't have enough information. Maybe they made a mistake. Who knows? But my point in the tenant takeaway is that some landlords bring the wrong case or on purpose, or they're just willfully ignorant about bringing the wrong case. Why would they do that? Because an illegal sublet case is much easier to get into court than a non-primary residence case is to get into court. It's another long story for another day, but an illegal sublet case is often the lower hanging fruit, easier case to get into court, and in some cases, easier to successfully prosecute, although obviously not here for this landlord today. So many landlords, when they see that the tenant of record is not in the unit, they just slap together an illegal sublet case and they go with that. So that's something very much to keep on your radar if you're a rent stabilized tenant. Number 2, what these tenants and occupants really needed to have done was document the succession of the occupant to the tenant's rent stabilized tenancy when the tenants left. In episode 6 of the Tenant Law podcast, we cover when and how family members and people that are like family members to each other should document their rights to succession to a rent-stabilized apartment, and I will put that link in the show notes. Number 3, finally, if you're sharing or using someone else's apartment and you're not the tenant of record, consider whether you're a roommate or a subtenant. And there's other things you could be too that we'll cover in future shows. But just keep in mind that your relationship to the apartment will ultimately affect what your rights are should there be an eviction case. So that's really the first thing you should be thinking about if something's happening with the apartment, and that's what you should communicate to your lawyer, the different circumstances of how you came into the apartment, if you have a lease, if you don't have a lease, and that kind of thing, because again, your relationship to the apartment determines what your rights are. And there you have it. Remember, New York City, the law belongs to you, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I am Michelle Itkowitz, and this is the Tenant Law Podcast.